Hi, it's Tim Grant.
And Nikki McLeod from the Writing Wrongs podcast. This episode contains discussion of murder and racial profiling. Listener discretion is strongly advised.
Our discussion will, as always, include an in-depth analysis of how forensic linguistic techniques can play a role in understanding the truth behind the stories.
We hope you enjoy the show.
Writing Wrongs, an original podcast series from the Aston Institute for Forensic Linguistics. Season 3, Episode 4, Linguistics, Life and Death.
Hello, and welcome to Writing Wrongs, the podcast from AIFL, the Aston Institute for Forensic Linguistics at Aston University. We're all about improving the delivery of justice through the analysis of language. I'm Professor Tim Grant.
And I'm Dr. Nikki McLeod, Deputy Director of AIFL. So Tim, who do we have with us today?
Our guest today joins us from Rice University, where he is the Barbara Jordan Distinguished Professor of Linguistics. He's past president of the Linguistic Society of America and the American Dialect Society, and he's also a fellow of both organisations. He's the Margaret Bush Wilson Distinguished University Professor Emeritus at Washington University in St. Louis and Professor Emeritus of Educational Linguistics at Stanford University. He has published widely in sociolinguistics and is perhaps best known for developing the theory of linguistic profiling, although it's quite a different type of linguistic profiling from the profiling we've discussed on Writing Wrongs before, and we'll get into that later.
Yes, that's right. So it's probably quite important to make this distinction for our listeners. When we've been talking about linguistic profiling before, we've been referring to kind of building a profile of an author, for example, for the purposes of an investigation, maybe for narrowing the pool of suspects, and so we'd make comments on their age, likely educational background, geographical background, those kinds of things. But the type of linguistic profiling our guest has expertise in occurs when someone's speech triggers discriminatory bias, but a bias against them, such as if they're seeking employment or housing or any of these kinds of things. So we're really looking forward to discussing that aspect of his work a little bit later. So it's as a result of this work and his expertise in black varieties of American English that our guest has served as an expert witness and consultant in various legal cases, frequently working with the United States Equal Employment Opportunity Commission, the National Fair Housing Alliance, and the United States Department of Justice, among other organisations. So welcome to Professor John Barr.
Thank you.
So it's really great to have you with us here, John. And as well as getting into detail about a couple of your cases specifically, we'll talk about your work more broadly in relation to Black American dialects, ear witness testimony, and your version, which is the more academic version, I suppose, of linguistic profiling and dialect bias and so on. But to start, let's hear about a couple of cases that you've worked on. These are reported in John's fantastic book, Linguistics in Pursuit of Justice, which we will link to in the show notes. We have given the individuals names to try and bring the stories to life, but all of these are in fact pseudonyms.
Yes, so let's open the case file.
Sometime in the 2000s, somewhere in the USA, John Smith, an African-American male defendant, has been accused of murder. While in jail awaiting trial, he makes a phone call to his cousin Joe. Speaking rapidly and loudly, John discusses the details of the case, and Joe offers advice that he hopes will reassure John and provide him with strategies for his upcoming defence. Since phone calls from prison are routinely recorded, law enforcement officers listen to and transcribe the call and believe they've unearthed a confession. On the recording, Joe's heard suggesting that John might request a speedy trial. Prosecutors claim John responded with, "Why would I do a speedy trial when I know I committed this shit?" The police produced a phonetic analysis and a transcript indicating these were the words that John uttered on the recording. The defence disagreed, but needed linguistic assistance to help them. Elsewhere in the country, tragedy has struck. 7-year-old Leona Harris was attending a house party with her father Robert. While standing in the front garden with some friends, they came under gunfire from a passing car. A number of the group were wounded, Leona and Robert fatally so. Under a great deal of public and media scrutiny, the police felt pressure to apprehend the suspects. They believed they'd identified the gang responsible and the individual who pulled the trigger and brought him in to be interrogated. However, they needed more information to charge him with Leona and Robert's murders. To obtain this, they approached a former member of the gang, Sidney Brown. Recently released from prison, Sidney was now a family man and struggling for money. Police descended on his house and told him witnesses had placed him at the scene of the shooting. If this was true, they said, he'd been in violation of his probation and would go back to prison. He needed to prove he wasn't there. Sidney reluctantly agreed to help the police gather enough evidence to arrest their prime suspect, Marcus Jeffries. At the police station, Sidney was provided with a mobile phone and instructed to call Marcus. The two discussed the events of the night in question and the possible location of the gun that was used. The conversation was recorded and transcribed, and the prosecution's case was that the transcript clearly showed Marcus agreeing to the proposition that he'd committed the murders, including that he stated he'd walked up on the dude and shot him and then turned right around and shot his daughter. Marcus's defense disagreed. Owing to his extensive research into Black American dialects, Professor John Bohr was approached by the defense teams in both of these cases.
Okay, so before we get into the specifics of these cases, let's introduce our listeners to the early days of forensic linguistics in the USA. In the UK, as our listeners have heard a great deal about, forensic linguistics is usually considered to have its origins with Jan Svartvik's work. This was in the late 1960s on the Timothy Evans statements. In season 1 of the podcast, we heard from Dr. Marlon Hurt at Hofstra, and he drew quite a lot on the work of Roger Shy, who I guess is widely regarded as being the grandfather of forensic linguistics in the USA. So what we'd like to do really is to just sort of ask whether you might be able to tell us a little bit about how and why did you stumble across the work of Roger Shy's work, and how has it influenced you?
So your listeners won't fully appreciate that I'm old. So I've known Roger since he worked on educational issues, and prior to any time that he had an inclination to work on forensic matters. And I'm not sure if your listeners are aware of the fact that Roger stumbled upon this work quite by accident. He was on a flight to Dallas and was sitting next to an attorney. The attorney wasn't involved in the particular case that he worked on, but there's a very famous murder case in the U.S., the Cullen Davis murder trial. And the significance of that case is that at the time, Cullen Davis was the wealthiest murder defendant ever in the history of the United States. But the consequence of that was that he had more resources to bring to his defense and enough resources to hire the very first linguist to work on that. And Roger ended up working on that case, and that opened a new career path for him that opened career paths for the rest of us.
Mm-hmm.
So let's turn to the cases that we just heard about in the case file. And the first case that we heard about was, we're calling the defendant John Smith, and it's what he said in response to his cousin's suggestion to request a speedy trial. So what we heard in the case file was how a phone call from prison played out and then affected his subsequent time in court. Could you just summarize let's start with what the prosecution position was on that recording and what the recording was purported to say before perhaps moving on to what your contribution was?
Well, for the benefit of your listeners, this particular case involved an African-American defendant who was in jail. And I don't know what the laws are here in the UK regarding recordings of prisoners in jail. But in the United States, if a prisoner makes a phone call, whatever they say will be recorded and potentially can be used against them in court.
It's the same here.
Yeah.
Okay. All right. Well, it's what we have some things same and some things different, right? We won't get into that right now, but if it comes up linguistically, that's another fascinating topic,
Yeah,
right?
for sure.
So in this particular instance, the defendant was speaking with a cousin on the telephone, and they were talking about the trial coming up. And in the United States, a defendant does have an opportunity to ask for a speedy trial. And you do that especially if you believe you're innocent, because you want to gain your liberty as quickly as possible. And if you think you have a strong case in that regard, you do that. So it's important for your listeners to appreciate that both men are speaking in an African-American dialect, because one of them is incarcerated in a prison setting. There's background noise. And the cousin on the outside asks the defendant, why don't you do a speedy trial? And the defendant said, what he literally said was, why am I do a speedy trial when I know I ain't committed this shit? All right. Mm. But the transcript that the prosecutor provided to the jury left out the word ain't. And in fact, suggested that, and in fact, the transcript was actually revised even more than that. Because the defendant literally said, why am I do a speedy trial? Not why would I want a speedy trial, right? Why am I do a speedy trial? Okay. Now I'm a do was, if you literally provide that as the transcript to the jury, they're not going to understand it. So the prosecutor modified the language in the hope to make it clear to the jury. But in so doing, the transcript was no longer accurate. And as a result of that inaccuracy and the omission of the word ain't, the jury was left with the impression that the defendant actually admitted guilt by saying, why would I want to do a speedy trial when I know I committed this shit? Am I allowed to say that?
Yeah, of course. Yes.
Oh, okay. All right. So,
language is language.
Well, language is language, but in the U.S., on the major broadcast networks,
right.
Yeah, we
words like that.
Righting Wrongs aspires to be a major broadcast. but we're some way off.
Well, after this podcast, we're doing it. So the fascinating part from my perspective, and also this ties into the forensic linguistics, because when I was called to asked to be to evaluate the linguistic evidence in the case, I told the attorneys, don't give me your impressions of what you think is going on. If you do that and we testify in court, the opposing attorney might say, oh, you've been programmed, right? Sure. So we needed to take care that I didn't prejudge what I was listening to. And what was fascinating in this particular instance was that the statement, I know I committed this shit versus I know I ain't committed this shit, really boils down to the presence or absence of a nasalized diphthong.
Okay, so for our general audience, can you just gloss what a nasalized diphthong is?
Oh, that's right. That's right. Not everyone out there is a linguist, right?
Sure.
So sounds that are nasal are produced through your nasal cavity, right? So in the production of speech, sounds either come out of your mouth or they come out of your nose.
Yeah.
And so the M sound and the N sound are nasalized because your mouth is closed while you're producing some of that sound, and the air passage comes through your nose. So the word ain't rarely has a final T pronounced.
Yeah.
It's often pronounced in rapid speech without that final T, so it's pronounced ain't. And that final N sound is a vowel sliding into the N sound.
Yeah. So just for our British listeners to break that down a bit. So in fact, the local Birmingham accent is quite nasal. I can't do it. Nikki,
Yeah.
can you say the word Birmingham in a Birmingham accent?
Birmingham.
Yeah, so it's quite nasal, and a diphthong, yes, is where you typically run two vowels together to create a new, mostly a vowel sound.
Right.
Yeah. So we've got this nasalized diphthong at the end of ain't without the t in ain't would be a consonant, so that's missing,
Right.
which creates it perhaps into the diphthong sound.
And more complicated in this case because the word that followed ain't is committed, which starts with a stop consonant.
Yeah.
All right. And T is also a stop consonant. So you could say ain't committed, but that's not normal speech.
You sound very English saying ain't
Yeah.
committed.
Yeah, that's
Yeah.
you know.
Yeah. It's just not how it's generally
Not in normal speech,
Yeah.
and especially not, in a jailhouse call. Right.
Sure. So just to get into a couple of points from that. First is this issue of transcription of dialogues taken to court. So we've had a lot of projects here at Aston, led initially by, say, Kate Howarth, but with also Felicity Deemer and Zoe Adams contributing and so on the process of transcripts and how they are produced as evidence in court and how they differ from the original audio version. So in this context, would the normal process, the normal practice be that the court, the jurors, or whoever the decision makers are presented just with the transcript, or would there also be tapes played and things like that?
That's up to the judge.
Okay.
And in this particular case, that question came up because the prosecutor had not called for the jury to hear the actual tape. And I was hired by defense attorneys who initially didn't call for that either.
Okay.
As a university professor, I tend to be long-winded. And court proceedings are such that attorneys are trained to ask yes or no questions. And it was not my intention to violate that norm, but the scientist in me wanted the jury to understand the complexity of the situation. And frequently when I was asked yes or no questions, I did not respond with yes or no, which annoyed the prosecutor greatly. I was fortunate because the judge rarely has a linguist in the courtroom, and the judge was curious as to what I was going to say. So the prosecutor would object, Your Honor, he did not say yes or no. And the judge would say, well, let him say a little bit more.
Yeah.
And so I was able to talk about the fact that the transcript did not faithfully reproduce the compacted pronunciations that were attributed to the dialect. And eventually I blurted out, play the tape.
Yes.
Which and so they did play the tape, and the jury did see that my point about what was actually said versus what was provided in the transcript was more precise. However, from the standpoint of the prosecutor, was the prosecutor's intention to obfuscate, or was the prosecutor's intention to clarify? I can't know that. And it would be inappropriate for me as an expert evaluating the transcript or evaluating the tape to speculate about the inaccuracies, right?
Sure.
Although I could point them out.
Yeah.
So essentially, the prosecution have said this is a confession.
Right.
You've pointed out that actually, no, there's something else going on here. There's an ain't where one hasn't been transcribed. It's not fully articulated, as you've pointed out, but it is there. The prosecutor, I understand, raised the issue that there's ain't elsewhere in the speech, but where it is fully articulated, and kind of said, pose this as a question to you. How did you respond to that?
Right. So we've talked about this a little bit briefly, but under certain circumstances, the T is pronounced, and in other circumstances, it's not. So the T is often fully pronounced when the word that follows begins with a vowel. But if the word that follows begins with a consonant, it's often omitted. And I tried to get into some of that without losing the jury. And your experts, not just me, but others that you've talked to, have probably mentioned that when you're presenting scientific evidence to a jury of non-experts, you have to tread carefully because you can lose them, and you can lose them for different reasons. And although you haven't mentioned this in your podcast, people who don't see me may not realize that I'm African American, right?
Okay.
And you can see that I'm a mixed race African American, right? So I don't know who my white ancestors are, but my light complexion belies the fact that some of my ancestors were slave owners who impregnated their slaves, right?
Sure.
So that's an inescapable fact of U.S. history that's relevant. But in this particular instance, when the jury could see me, did they question my expertise and believe that I was actually trying to help an African American defendant, right?
Yeah,
Was my expertise called into question because I want to help another brother,
yeah.
Get out of the system?
That's really interesting, isn't it? Because
Good. I was trying to go for interesting.
Yeah, no, sorry, that's a terrible. That's a linguistic quirk I have. I have to take interesting out of all my writing.
That's all right.
But so what I was coming to was sort of the general status of an expert witness in court is a sort of a high. So particularly in the UK context, is considered a high status, more neutral witness, and so on. And what you're talking about is the racialized context of a trial like this, and you being an expert in that trial maybe comes into tension because of the racial issues.
Potentially. Now, I had the benefit of being able to see the jury.
Yeah.
So when you testify in a case like this, you can observe the people in your immediate proximity. I could see the defendants, prosecutors, the judge, and the jury. As I looked at the jury, and it was a multiracial jury, men and women, it wasn't clear to me that all of them were native speakers of English, right?
Yeah.
Because we have many U.S. citizens that are not native speakers of English. They serve on juries, and I'm talking about very, very slight dialect differences, to say nothing of the stereotype that African-American dialect has historically been associated with low intelligence in the United States, right?
Sure.
So you're, swimming upstream in a case like this to try to make the small point that I was making. That was the difference between innocence or guilt and potentially life or death. It did boil down to that single sound, whether it was present or absent.
So that single consonant actually became a focus. In the prosecutor showed you a speech spectrogram where you'd normally expect to be
I showed him.
You showed him a speech.
I showed that.
Tell us about that then.
Yeah. So because I did not have access to the defendant, what would have been ideal from my standpoint as a researcher would have been to ask the defendant to come to our phonetics lab to reproduce their recordings and then to measure them with great precision and present them in court. He's incarcerated. He doesn't have bail. He can't get out. But I knew his age. I knew his linguistic background, and I had the recording. So I was able to record 5 other African-American men, approximately his same age, very similar linguistic backgrounds. And then we went into the phonetics laboratory, and I had them under headphones as we are now, and they would listen to his recording. Why? To make sure that the pacing of the speech was identical to that was used in the courtroom. And I had them produce the utterance, I know I committed this shit, and I know I ain't committed this shit, right? Mm. And then I did an evaluation, used a spectrographic analysis of comparing the two pronunciations, and visually you can see a stark contrast between the one where the nasalized diphthong is present and the one where the nasalized diphthong is not present. And so by having that evidence available in court, something that is difficult to hear in rapid speech and passing on at first glance, is reinforced visually when you have the spectrographic analysis to show.
Sure. So that's interesting. I've got a question that's just occurred to me, which is, I don't know whether you know the work of the Australian linguist Helen Fraser, who does a certain amount of work on covert recordings and transcripts. And where she's ended up is that the court should never be shown the transcript, because if you have a transcript alongside the audio, the transcript biases the hearing of the audio. It primes the audience, the jury, whoever, to hear or not hear. What is that? I'm just wondering, given your experience in this trial, where would you position yourself with that? Would it have been better to play the jury just the tape and talk about the tape, or does the competing transcripts, do they have a role?
Yeah, that's a fair and very good question, and it gets more deeply into who is a reliable ear witness in a case like this. And ear witness reliability is commensurate with a person's linguistic experience. So in the United States, and I know the U.S. situation much better than the situation here in the U.K., we know that people that grow up in the Northeast, in Massachusetts, they can often hear and distinguish subtle differences between a Massachusetts dialect, a New York dialect, Philadelphia, and Baltimore. Someone who grows up in New Mexico, their ear can't decipher those differences. Someone who grows up in Alabama can often distinguish between someone who grows up in Kentucky or Tennessee or Mississippi or Texas. And yet someone from Minnesota, those southern dialects all mesh together. So when you're presenting the tape to listeners and you don't know the background of the listeners, you have no awareness of the potential accuracy that they're hearing. And that's for dialect differences, right? Sure. And it's if you're looking at different languages, it's another situation altogether. Also, and Tim, I know you have some experience with this, you're dealing with the facts as they're presented in the case, of course, right? Of course. So, the reality was the prosecutor presented the transcript to the jury as the prosecutor believed was the best presentation of that evidence. The fact that I could show that the transcript had inaccuracies was important from the standpoint of the defense. It's difficult for me to prejudge whether having the transcript or not having the transcript would have made any difference. And, in cases like this, you have to take the facts as they come. And so I just, ride the horse they put me on.
On that then, so what was the outcome? What was the overall kind of verdict in the case? Well,
so the defendant was found guilty.
Okay.
But they took the death penalty away.
Right. Okay.
And that was huge because now also when I serve as witness, when you're a witness in a trial like that, you're only in the courtroom for your testimony.
Yes.
Yeah.
Right? I don't get to watch what other people do because that could easily influence my testimony. I mean, the witnesses are not necessarily impartial. So you're sitting in the hallway. Your experts know that you're often paid quite nicely for that time twiddling your thumbs. And then you're called into the courtroom, you're sworn in, you give your testimony, and then you're excused. What happens after that, with other witnesses, you don't see and you don't know. I do know that he was found guilty, but I also know that they took the death penalty away. And I assume that my evidence had something to do with that because, if you put someone to death, and then there's exculpatory evidence that comes to light later,
it's too late.
You can't bring them back.
No, that's right.
We've covered a couple of cases.
We have, we've talked about.
You brought people back?
Oh, no, no, if only. No, but we've talked about a few cases where it's been, we've had posthumous pardons, but this is, it's kind of.
These are historic cases in the UK context because, of course, we no longer have the death penalty.
Yes, exactly. So, so we had a guilty verdict. but the death penalty was taken away. And we have also talked before on the show about how we can never really know how significant our evidence was. We never really know the full picture of what other evidence there was. And quite often, for example, we do sort of TV shows or in interviews or something, they'll say, how important was your evidence in this verdict? And we don't know. We go in, we do our bit, and then we go away. And then we'll probably find out the verdict at some point later, but we don't actually know what our role was. So it's...
So let me ask you, I'm sorry I shouldn't take over the interview, but
I understand you do this with the prosecutor.
That's right. That's right. I did do that with the prosecutor.
But go ahead.
But do your judges have the authority to admit or deny an expert?
Oh, absolutely. So it's complicated here, and we have been, so the UK common law basis is the same as in the US, that an expert witness has to have the qualifications and experience. But in the US, in the federal courts, at least on top of that, you have the Dober criteria, which basically is an attempt to ask the question, how scientific is the evidence?
Right.
Is how I take the Dober criteria.
Right.
And that has been influential in the UK, but it's not adopted by the UK.
Right.
Instead, there was a proposal to bring in something like that, but instead they brought in a forensic science regulator who sets standards for forensic science and admissibility, which the court will pay attention to. And some of this is really positive, I think. So the forensic science regulator is very strong on that the expert witness is there to assist the court, not to advocate for one side or another. And we have to sign really serious declarations to that effect in our criminal practice directions, which means because we sign that as part of our report, you can be accused of contempt of court if you're overly partisan.
Right.
And that has happened in medical negligence cases and so on, where doctors are signing off all sorts of stuff as a sort of industry to make money, and actually they're entirely partisan. So the forensic regulator is very influential, and not in linguistics, but in forensic speech science, comparative voice analysis and stuff. There are actually standards set out as to what good forensic practice looks like. And then if you go to court with something else, you can be given a hard time by the other side.
Well, I'm going to stop asking you questions because you're going to take over. But the point that I wanted to make about this was I have served as an expert witness, written reports, and had judges not want to admit the evidence. And it wasn't clear to me what the rationale was on the part of the judge as a trier of fact for dismissing me. One of the cases, we talked about linguistic profiling, and I know you're going to get around to that, but one of the housing discrimination cases that I worked on, the judge asked if I myself, as the expert, had actually tried to rent the apartment. And when I said no, I had not, he dismissed me. So all of the work that I had done for the defense attorneys wasn't admitted.
Wow.
But it was based on the judge making the decision, okay, you're not the victim of discrimination, your expertise is not relevant to the case.
So to use an American expression, admissibility in the UK can also be a bit of a crapshoot.
Okay.
Right?
All right. Yeah, that's a technical term.
So we do get excluded from giving evidence as well. So and sometimes we have no idea why.
That's why we have appeals courts, right?
For sure.
Yeah. I think we need to move on to the other case and we'll just sort of talk about that one. So we heard in the case file that this is all about the tragic shooting of a 7-year-old girl and her father outside a house party. The police used a former gang member to engage the suspect and they tape recorded the conversation. So how did you first become involved in this case?
So in this particular case, I was hired to evaluate a transcript that was produced by an undercover confidential informant. I was about to say snitch, but he's not a snitch.
In UK jargon, a chiz, a covert human intelligence source.
Oh, look at you all. All right, go ahead. Yeah. So, all right, at any rate, a confidential informant. The confidential informant is an adult gang member who was on parole, right? So he had been incarcerated and served his time in prison, was out of prison, and the drive-by shooting in question, which happened in a major urban U.S. city, was between two rival African-American gangs, right? So car drives by, automatic weapon fire, a man is killed and also his daughter's killed, a couple other people wounded. The police believe they know who did it, and they're trying to get more information on that person. At the time that they bring in the person on parole, his girlfriend had talked to the police and said that, in fact, he was at the party, right? So again, I don't know how it works here, but in the United States, when the police and prosecutors have an eye on the defendant that they want the most, some of the witnesses that they interview are not, savory characters, and they potentially could, so this guy that was on parole, he had violated his parole by being at the party. He was seen at the party, so parole violation, you go back to jail for a period of time. But they don't want him because they don't think they know he didn't do it. But if he knows who did it and he's friends with the guy, then maybe this undercover phone call can release that, right? So I was given a video and audio transcript of the police officers with this, former parolee talking on the phone to the prime suspect that they thought had committed the murder. And when they get on the phone, at first, the phone call is coming from an unidentified number. So the suspect answers the phone, and then the parolee immediately says who he is. And the suspect recognizes his voice, so he's no longer suspicious. But that blocked number was because it was from a police phone. And in this particular instance, it's similar to the previous case in that the prosecutor presented a transcript at trial that clearly looked like the transcript indicated guilt on the part of the man who was the suspect. They talked about a lot of different things, where he was, where the suspect was, his car broke down, he needed to do some other things. And the police at the station were handing the parolee notes to try to prompt his conversation. And they wanted to know where the gun was. And he asked, and he referred to the gun as the heater. And he says, where, you need to get rid of that heater. And the suspect said, well, he said, that motherfucker's gone.
Yeah.
He said, I don't know where it is. That motherfucker's gone. Right. So that implies that he knew where the gun was, but it doesn't necessarily say that he did it. Right.
Sure.
So when they were talking further, the part of the transcript that was presented to the jury that looked like was an open shut case was, he did say, so I walked up on the guy, I shot him, and then I turned around and I shot his daughter. Right. And that's presented as a declarative statement to the jury. They read that. But when I actually heard the recording, the suspect was making the point that typically in a drive-by shooting, if there are children present, there's an understood code that you don't shoot in that context because a kid could get hit. And so what he said was, so I walk up on the dude, I shoot him, and then I shot his daughter?
Yeah.
Okay. And so what I realized was that there was a bit of like sarcasm that the written transcript couldn't convey.
Yeah.
The literal words suggested that he might have shot his daughter. But when you heard the question intonation, it was very clear that he was making the point that he didn't shoot the daughter. And the only way to determine that was to hear the evidence. So in that particular instance, and that was not me testifying in court, that was me giving a report to the court saying that, without listening, that the triers of fact, I strongly encourage them to listen to the tape rather than merely read the transcript.
Yeah. Yeah, and this reminds me again of for the record work and everything they've done around the issues with transcription, what it can't capture, and how a lot of the stuff it can't capture may actually be very, very important in terms of the decision that the jury makes or the impressions that they form. And this is a very extreme version of that, isn't it? Really?
Yes, yes. So in that work, they've studied things like how overlaps and pauses and other. This is mostly because most police interviews, we call them, rather than interrogations, are tape recorded in the
sweet.
All suspect interviews have to be tape recorded in the UK. At least tape recorded, some are video recorded. And so, but what's mostly used is the transcript.
Right.
And so this particular project studies on how aspects of transcription affect the uptake by the jury or the trier of fact.
Right.
And they've shown remarkable findings about how you represent pauses and silences can affect the credibility of the witness.
Yeah.
So, but this is subtlety, yeah? What you're talking about is brute sarcasm and things which
also
cannot be captured without,
there's some research that was published in the journal Language by Taylor Jones a few years ago that looked at the fact that many court reporters who are white have inaccuracies in their transcripts of black defendants and black witnesses, and that has a large part to do with the dialect differences and
for sure.
mishearings.
This is can they hear it question again,
and misinterpretations.
So your report was to say listen to it essentially, and anyone who listened would sort of disagree with
whether they would disagree or not, I can't determine.
You can't determine.
But they would have a different basis upon which to determine whether or not the comment, and then I shot his daughter was in fact an admission of guilt or skepticism that he would have conducted that act.
Sure. And so that was the important point, that it gave rise to another interpretation which wouldn't have been there otherwise.
Yes.
Okay, so we've heard about two cases there, both of which demonstrate how linguistic insight can kind of contribute to improving justice. You talk in the book as well about how the fact that linguistic expertise is required, that's quite often overlooked by the system, by judges, by the legal system in general. And I just wondered if you had any thoughts on why that might be. Why are we overlooked?
Well, language is ubiquitous, right? And nearly every normal person has strong linguistic opinions based on their own linguistic experience. And so linguistic evidence is often overlooked because it's not perceived as necessary. If you speak the language, then why would you need someone to tell you about the language that you know? And sometimes it's frustrating, and in other instances, it's revelatory. And it just depends in part. I mean, one of the reasons that I asked the question that I asked previously about the impact of judges is some judges are dismissive of the evidence even before they hear it.
Yeah.
So, you can't do anything about that when the legal trier of fact simply blocks the information from coming forward.
Yeah, that's right. I suppose that everyone that uses language kind of thinks they're a sort of an expert, but I suppose the legal profession in particular, they see language as their craft and their domain and so on.
Oh, I'm going to get myself in trouble.
That's excellent for our podcast.
Well, everyone has a degree of linguistic insecurity. Everyone.
Yeah.
Sure. And attorneys may be reluctant to admit it.
Okay.
But they too, they wallow in language, written and spoken. Some of them are better at it than others. But scratch the surface and you find linguistic insecurity.
Yeah, that's an interesting framing of this. But I agree.
I said it like
interesting again.
I'm old, right? So plus, I have had the good fortune of multicultural, multilingual exposure in the U.S.
Sure.
Right? Now, you both can see me, but other people can't. And as I travel the world, if I'm in Brazil or South Africa, many people think I'm from that
That's
place.
interesting, yeah.
And as long as I don't say anything,
Yeah.
they don't know I'm an American. So in South Africa, people come up to me and speak Afrikaans.
Okay.
In Brazil, they'll come up and speak Portuguese and ask for directions.
Yeah.
And I try to nod my head and gesture until the absolute last moment. And now you understand, because of my background in the United States, depending upon the community that I'm in, I'm going to slide and switch up my speech a little bit. And you guys do that here in the UK, right? You got West London, East London. You got a lot of dialect diversity here.
Oh, definitely.
I mean, for heaven's sakes, this is the land of Pygmalion, right?
Yeah, absolutely. Absolutely.
Yeah, I've been known to slide into my Dorset.
Look
at how you guys should see the body language and stuff like that.
Yes, I come from the bit of England and was educated in the very standard variety of English. So,
it shows.
And so I struggle more with the accents than other English, native British English speakers. Perhaps.
You're forgiven, Tim.
Yeah, thank you. So let's get on to the issue of ear witness testimony. And famously in the O.J. Simpson trial, the prosecutor asked a witness whether they'd heard the voice of a black man, referring to...
I wonder if some of our younger listeners might need to be told what the O.J. Simpson trial was.
So for your younger listeners, O.J. Simpson was a professional American football player and very famous, an African-American man who grew up in San Francisco, attended the University of Southern California. He received the Heisman Trophy, which is the college American football player's highest award, and went on to an incredibly successful career as a professional American football player, and then on to acting and TV. He was a celebrity. He was probably one of the most famous African-American celebrities, recognizable. And he had initially married an African-American woman at a younger age, had children by her, divorced her. And then he married a beautiful blonde white woman many years younger than him named Nicole Brown. And Nicole Brown was the mother of two of his beautiful biracial children. And they had a volatile marriage. They lived in Brentwood, which is adjacent to Beverly Hills, in a very affluent neighborhood. And at this point, at the point of the murder case, they were separated. Nicole had moved out of the mansion. She had called the police on various occasions to have the police come because he had been abusive and physically, grabbed her and hit her. They weren't yet divorced, but she had moved out with her children into a condominium, was living her own life. And on the evening in question, she went to a restaurant, and a young man named Ron Goldman, a very handsome waiter who was her friend, accompanied her back to her condominium, and someone brutally murdered the two of them. Brutal, horrific murder, stabbing. There were footprints left behind, some controversial evidence of blood on a glove. This was O.J. Simpson's wife. So they immediately tried to get in touch with O.J. Simpson, and he was in Chicago. He flew back to Los Angeles, but as the facts of this case unfolded, O.J. Simpson had, in fact, been in Los Angeles at the time the crime was committed, took a late flight to Chicago so that by the time the bodies were discovered, he was no longer in Los Angeles. This was a riveting trial that was on national television in the U.S. for weeks at a time, and included a scene where O.J. Simpson, after being accused of the murder, tried to escape with one of his friends who was a former American football player, another African-American man, and the two of them drove down to San Diego, which is about 90 miles south of Los Angeles. They were spotted on the freeway, And there's just, you young people, look it up. O.J. Simpson trial. There is no shortage of footage.
Series, isn't there?
There are books, miniseries, trials. I mean,
all of it.
So this became interesting to me because the prosecutor, an African-American named Christopher Darden, had asked a white witness who had overheard voices at the scene of the crime whether or not he heard the voice of a black man. And he started to speak when Judge Lance Ito stopped him and said, "Stop, don't say any more." And the witness started to speak a little bit more, and the judge just adamantly said, "Just stop." And so the witness kind of threw up his hands, and then O.J. Simpson's defense attorney, Johnny Cochran, forcefully objected and said, "Wait a second, you can't tell a person's race based on the sound of their voice. I object to this testimony." Now, we know in hindsight that many of the jurors were African Americans, right? And what I know from my own life experience is that the devaluation of the African American dialect has been such historically that the majority of African Americans in the U.S. are aware of linguistic bias and linguistic sensibilities in that regard. So claiming that you can tell someone is black based on the sound of their voice is potentially controversial. And in this particular instance, if Johnny Cochran, the defense attorney, let that go without objection, that could have been introduced in the case. Now, I want to point out very briefly that identifying witnesses based on their voice has been a common practice in the U.S. for many, many years, right? So in many bank robbery cases where the bank robbers have concealed their faces, or instances of rape and sexual crime where the victims have not seen the face of their perpetrators but have heard their voices, defendants have been compelled by the judges to say particular phrases or statements, and then witnesses are able to say, "Yes, I recognize that voice," right? So we all know people well enough that just based on the sound of their voice, we know who they are. And then there are people that we don't know, and when we hear their voices, we will often form the type of linguistic profile that you were talking about. What are the demographic characteristics of that individual? Is it a man, a woman, old, young, British, American, if I can go there?
Yeah.
And in this particular instance, was it the voice of a black man that was heard at the scene of a crime, right?
Sure.
So on a kind of related note then, this idea that people make inferences about the speech that they hear, the speakers that they hear, and they potentially draw on negative stereotypes about who they think is speaking. Obviously, that can kind of lead to discriminating against those speakers. And this brings us to the term that you've developed, linguistic profiling. So this is, as you mentioned at the top of the episode, actually akin to racial profiling. Racial profiling would be when you use the kind of visual cues to sort of draw those inferences about somebody. And this linguistic profiling is based entirely on the properties of somebody's speech. Can you talk us kind of just very broadly through the work you've done in this area?
Yeah. So let's go back and review that. So for many years prior to developing the concept of linguistic profiling, I had been looking at issues of linguistic discrimination in one form or another. Sometime in the 1990s, evidence came to light that police officers, highway patrol officers in the state of New Jersey were disproportionately stopping African American and Latino drivers, right? The population of those drivers in New Jersey were minority populations in the teens, and the percentage of stops on the highway based on race, we had them in the 60s and the 70s. So the term racial profiling was used to describe what the police were doing in those. There was, just statistically, you could not justify that number of minority people, right? A minority group with a majority of the police stops. What's going on there, right? And so they called that racial profiling.
Yeah.
And it was during the course of some of the work that I was doing on housing discrimination that I realized, oh, there are people that are being denied housing based on the sound of their voice over the telephone. There's an organization in the U.S. called the National Fair Housing Alliance, and they conducted a series of experiments with in-person couples that were biracial, as well as phone calls made requesting apartments. You say for let, we say for rent.
Both ways.
Does it work? You can rent a place? I just saw these signs for let.
Oh, yes. In written English, yes.
Oh, okay. All right.
But we
Okay.
speak
Well, I'm living and learning. So what we observed was many of the people calling who had minority dialects were denied access to the housing, right? And I had actually been in a situation. I was a professor at the University of Texas at the time, and I had been invited to spend a year at Stanford University's campus at the Center for Advanced Studies in the Behavioral Sciences. It's a think tank and an honor as an academic to be invited there. You were nominated. You couldn't submit an application. It was really quite a distinction, and it was an absolutely wonderful place. But when I went there, I needed to try to find a place for my family to live. And so I was calling around to various places to look for an apartment or a house to rent. And your listeners can hear my professional voice. You may not detect that I'm African American by hearing my speech. And when I called for these apartments, I was using my professional voice and also did not lie when I said I was a visiting professor from the University of Texas and spending a year at a think tank in Stanford. This you would think on the surface of this, this might be a good person to rent to, right? But in about 3 or 4 cases when I showed up in person, I was told, oh, we've made a mistake. Now, none of those prospective landlords said, oh, I'm sorry. Had you sounded black over the telephone, we would have never given you the appointment, right? But because of where I grew up in inner city Los Angeles, con los vatos allá, I had some dialect dexterity that I developed as a child because I grew up in a multiracial neighborhood with Chinese Americans, Japanese Americans. And to my discredit, I used to make fun of my classmates by mimicking their dialects. My original dialect, my parents were both college educated, and they emphasized, like you, Tim, the benefits of speaking standard English, and in my case, standard American English. And yet my peer group of young black men devalued that. So I was bidialectal at an early age. But we also had a lot of Latino students that were part of my classmates. So I could modify my speech. Sometimes I sound like a Chicano if I want to, and, influence that Spanish accent as well, right? So when I was denied the apartments, I talked to some attorneys. They said, oh, you could sue these folks. That wasn't how I wanted to spend my year on leave. And I realized I also had young children at the time, so the likelihood that I could continue going out and doing the field work that I had done years before was less available. But the telephone was available to me, and so I started to set up an experiment where I always used the phrase, hello, I'm calling about the apartment you have advertised in the paper. This is long enough ago that you looked for apartments in the paper, right? But I would modify my speech. I use the same phrase, you understand? I say, hello, I'm calling about the apartment you have advertised in the paper. Or, hello, I'm calling about the apartment you have advertised in the paper. Now, the psychologists who are listening to this podcast will say, oh, my goodness, that's a controlled experiment. That's absolutely right, okay, because it's me. So if my professional voice is granted access and the minority dialects are denied access, that's discrimination.
Yeah.
You want to ask a question?
That's the matched guys technique. Am I right? Is that?
It's similar to the match guys technique. It's influenced, but the match guys technique was originally done between Canadian French and Canadian English.
Okay.
So,
Okay, so
it's more complicated in a bidialectal situation, but very good for you to. And do your listeners know what the match guys technique is?
I think they might do. I mean, it was
You
just
tell 'em.
going to lead me to asking about some research that's been carried out that was using the matched guys technique, where they were looking at assessments of criminality for particular types of crime. So there's some work done by Segi in Australia and then by Dixon in the UK, where the Segi, the Australian one, compared a sort of, I think, an RP, so a sort of standard Southern British English accent, to an Asian Australian accent, to I'm not sure if it might have been just a kind of ordinary Australian accent, and asked people to assess how likely is it that this individual committed this particular type of crime. And so they found that only the RP, sort of standard British English speaker, was deemed to be intelligent enough to pull off a kind of embezzlement or a check fraud or something like this, whereas they were considered, there was no way they would be found guilty of a kind of violent act.
That's the business I should go into then.
Yes, maybe it is. Yeah, absolutely. Because I did something very similar for my master's dissertation research, actually, where I compared regional accents of the UK. And I had separate speakers doing that, but the matched guise technique would be if you had the one speaker who was adopting different guises, i.e. adopting different varieties and using those.
Yeah, there was one time I was giving a lecture on this topic, and someone in the audience asked, well, what about a female rendition? And I said, there are limits to the the lengths to which I will.
To your guises.
Exactly.
So then your formulation of linguistic profiling, starting with these housing contexts, is quite different from what Nikki described as the forensic linguistic profiling type tasks that we've engaged in. Can you perhaps comment on the relation between the two and how they might feed into one another?
So my formulation of the concept of linguistic profiling, which I developed around the year 2000 in response to the housing discrimination study, was focused exclusively on someone being denied goods or services based on the sound of their voice over the telephone. And that type of discrimination is illegal. It's difficult to confirm in a court of law. Although it was initially developed with respect to racial issues, it expanded over time because we did some experiments, for example, that showed women who were applying for executive positions were denied. And there were also stereotypes associated with sexual orientation in male speech, where men who spoke and were perceived to be gay were denied opportunities. So linguistic profiling isn't necessarily based on race, but my definition focuses on crime. There's discrimination based on you've been denied goods or services, which is a crime. You make a phone call because you speak with a dialect. Someone says, I'm sorry, that job's not available, but the job is available. You have been the victim of a crime, right? But if someone is listening to a person and they come up with a demographic assessment, which is the type of profiling you're talking about, there's no discriminatory effect. And in fact, it's quite natural. If you hear the voice of a stranger, you're going to develop a type of profile about that person that has nothing to do with discrimination whatsoever. And in fact, it's normal. In many of the cases that we worked in for the housing discrimination, the defendants would try to deny that they could tell that a speaker was African American or Latino. And in those instances, when the judges would allow us to conduct some experiments, we would start with, can you tell the difference between a child and an adult? Can you tell the difference between a New Yorker and a Texan? And we would gradually move toward the case. And it was interesting to observe the juries in those instances because at a certain point in time, the defendant would have to say, no, I can't tell the difference. And I could see by the jury that the jury could see the difference. And those are the cases that typically settled out of court on the benefit of my clients.
That's fascinating.
So thank you. I think we're going to wrap up the episode here. So thank you, Professor Barr, for joining us on this episode to talk about the fascinating work that you've done and for giving our listeners an insight really into how linguistic analysis can improve the delivery of justice. That's what we're all about here at Righting Wrongs.
So yeah, it's been a great conversation. Thank you.
Yeah, I've enjoyed it tremendously. Thank you so much.
So if you've got a question, remember you can get in touch with the show via email, writingwrongs@aston.ac.uk.
If you've been affected by any of the themes in this week's episode, please consider contacting the resources in the episode description.
This has been Writing Wrongs, an original podcast series from the Aston Institute for Forensic Linguistics at Aston University. We'll see you next time. Goodbye.
Goodbye.